Good afternoon, and welcome to today's webinar entitled, Who's in Charge Here? How Fair Housing Laws Will Shape Rental Housing Policies After the Mass SJC's Burbank Tenants Association decision and the U.S. Supreme Court's decision in Inclusive Communities. This webinar is hosted by the law firm of Krokidas and Bluestein and has been developed in conjunction with the law firm of Nixon Peabody. I'm Janet Lundberg of Krokidas and Bluestein in Boston, and joining me is Harry Kelly of Nixon Peabody's Washington office. Hello, Harry.
Hello, Janet. Nice to be on the phone with you, and welcome to all of our guests.
I was the attorney who represented the owners in the Burbank case, both in the trial court and in the appeal process at the Massachusetts Supreme Judicial Court, which around here we refer to as the SJC. Harry authored an amicus brief submitted in the appeal to the SJC on behalf of several real estate-related associations, including the National Leased Housing Association. Harry also submitted an amicus brief in the Inclusive Communities case that was central to the Burbank decision and which will also be discussed today. Both of us have followed the rulings and implications of these decisions over the last year. We have provided our contact information and our firm's web address so you can learn more about both law firms and our practice areas. Before we get started, the GoToWebinar program we are using today provides you with the opportunity to submit questions at any time during this discussion. You will find the question tab on the program's sidebar where you can type in your questions. Only the presenters see the questions, so you can remain anonymous. At the end of the presentation, we will address questions that have been submitted during our Q&A session to the extent that time allows. Now let's begin. As an introduction, I'd like to give you a little of the historical background and facts of the Burbank case to help you understand how this all unfolded. Burbank is an affordable housing development that was constructed in 1971 with federal subsidies, including mortgage insurance and interest subsidies, that permitted the prepayment of the mortgages after 20 years or by March 31, 1991. And it was subject to a regulatory agreement requiring Burbank to rent to low and moderate income families while the federal subsidy programs were in effect. They also had Section 8 project-based agreements with HUD, which provided the subsidy to low-income tenants with terms that were coextensive with Burbank's mortgage and regulatory agreements. Beginning in the 1980s, Congress began passing legislation to discourage the prepayment of mortgages, realizing that they could have a very large loss of subsidized units if everyone began prepaying. So through this series of statutes, Congress provided incentives not to prepay the mortgages and regulated the process of mortgage expiration and the owner's termination of related project-based Section 8 contracts. In conjunction with the legislation on mortgage payoffs, when owners became free to leave the subsidy system, Congress also created, among other things, the Enhanced Voucher Program in the 1990s. And owners were required to provide all qualified tenants upon termination of project-based Section 8 contracts with enhanced vouchers instead. And as many of you, I'm sure, know, enhanced vouchers are portable vouchers that go to all eligible existing tenants in a formerly project-based subsidy development, and that those vouchers pay actual fair market value, unlike housing choice vouchers. And the legislation passed in conjunction with the Enhanced Voucher Program guaranteed that all qualified tenants had the right to remain in the development once all of the other federal agreements were terminated. When they left the development, however, enhanced vouchers became mobile vouchers, which those tenants could then take anywhere. Correspondingly, when enhanced voucher tenants left the units where they had received the enhanced voucher, the owners became free to convert the unit to a market rate unsubsidized unit. And just as a note, in contrast to the enhanced vouchers, as I mentioned, regular housing choice vouchers do not pay actual fair market value in many situations at least. And so it would be the case in high cost areas such as Boston that housing choice vouchers might be unable to live at Burbank or similar developments coming in from the outside. Also, during this period, the state of Massachusetts passed a statute, Chapter 40T, that also regulated affordability terminations. So, in response to all of this, what the owners of Burbank did was they did agree to take advantage of the incentives offered in the 80s and 90s, and they agreed not to prepay their mortgage and entered into a new use agreement and a Section 8 project-based subsidy contract that ensured affordability at the development through the expiration of all the agreements on March 31st, 2011. When that time came around in 2011, the owners of Burbank decided to exercise their option not to renew the project-based Section 8 agreement when the mortgages expired. However, in doing so, they fully complied with all of the federal and state notice and other requirements, and they implemented the enhanced voucher program. And there was a quirk to this, which is under one of the statutes that was passed, they exercised the option to actually prepay their mortgage by just a few weeks, I believe. And as a result of that, the program awarded extra enhanced vouchers to the Burbank development. And so with that and the owners' extensive efforts to make sure that all qualified tenants were approved, they actually obtained a total of 171 enhanced vouchers for the development, which was enough for both the 67 existing subsidized tenants plus any other tenants who qualified, and the remainder that were not used at Burbank went to the city of Boston. Nevertheless, a lawsuit was filed against the Burbank owners, brought by a tenant organization, some individual tenants, and potential tenants, and community organizations that represent the interests of low-income Boston residents. They filed claims of housing discrimination under the Federal Fair Housing Act and the state housing discrimination laws. The basis of their claims were twofold. First, that the decision not to renew the project-based Section 8 contract had a disparate impact on protected classes generally and exacerbated segregation in the city of Boston because over time, fewer and fewer subsidized tenants, they claimed, would be able to live at Burbank as enhanced vouchers tenants left and regular voucher holders were unable to afford the rent at Burbank. Secondly, they brought claims actually on behalf of the existing subsidized tenants and those who received enhanced vouchers, and as well as potential tenants who they felt would ultimately not be able to afford to rent at Burbank. On behalf of the existing tenants, one of their allegations was that the enhanced vouchers were not as beneficial to tenants as the project-based subsidy. Lastly, they brought a claim of subsidy discrimination as compared to housing discrimination under the state subsidy discrimination law, Chapter 151B, Section 410. Based on a claim of that the refusal to provide or accept project-based Section 8 subsidy discriminates against tenants who otherwise would have had project-based subsidy available to them at Burbank. In response to the claims, the Burbank owners took the following positions. First, they claimed that owners who participate in highly regulated federal finance and subsidy programs and who complete their obligations after 40 years and comply with all federal and state requirements for terminating and providing alternative subsidies cannot, as a matter of law, be subject to claims for housing and subsidy discrimination, because basically to do so, we claimed, was to defeat the purpose of all of the many statutes that Congress had put in place regulating those programs. Secondly, the owners claimed that even if such claims of discrimination were viable, the plaintiffs had failed to assert an adequate claim of disparate impact under the U.S. Supreme Court decision in Texas Department of Housing and Community Affairs versus Inclusive Communities Project, which was actually decided in June 2015 while this Burbank appeal was pending. And thirdly, we claimed that choosing among subsidy programs equally offered to tenants doesn't violate the state subsidy discrimination statute. Briefly and in summary, the decision of the SJC, which is we're going to talk about more at length, was threefold. Again, the court did not adopt a per se bar to disparate impact liability under the fair housing statutes, where a property owner has complied with all program and contractual obligations. And secondly, the court applied a rigorous pleading standard to disparate impact complaints alleging housing discrimination as laid out in Inclusive Communities, and required that plaintiffs allege facts showing that the defendant's policies directly caused any disparate impact on protected classes. And it held that the plaintiffs had failed to show such impact. And thirdly, the court rejected the subsidy discrimination claim under state law. Now, before we move on to really what's the main event, which is the housing discrimination decision, I wanted to briefly go over with you the decision on the state subsidy law discrimination claim, because I think it provides important new information, really, for owners on their obligations to take or provide particular types of subsidies. The statute that I mentioned makes it unlawful to discriminate against an individual who is a recipient of subsidy of any kind, including rent subsidy, and to discriminate because the individual is such a recipient or because of any requirement of the subsidy program. The plaintiffs asserted that for existing tenants, the enhanced vouchers were less beneficial than project-based subsidy, and that for potential future tenants, the termination of project-based subsidy lessened the chances they could rent at Burbank, as I mentioned. The plaintiffs were relying on a somewhat conflicting case law in Massachusetts on whether and in what situations a provider or owner could be subject to liability for refusal to participate in a voluntary subsidy program like the project-based Section 8 program. What the SJC did was basically to split the difference. The SJC stood by their ruling that a decision not to enroll in a voluntary government program does not by itself violate the statute. But it also explained that the fact that the programs are voluntary does not shield them from adequately pleaded claims. However, the court found that no adequately pleaded claim on subsidy discrimination was stated. With respect to existing tenants, what the court ruled was that the owner's decision to end project-based subsidy had not placed a barrier to tenancy, because although the owner rejected the project-based subsidy, it had provided a lawful alternative, which was the enhanced vouchers. So therefore, basically, no tenants would be left behind in this process, and no barriers to their continued tenancy at Burbank had been erected. And secondly, and most significantly, the court ruled that even if enhanced vouchers were less beneficial than project-based subsidy, which it didn't rule, but it said even so, the subsidy discrimination statute requires only that owners not discriminate against subsidy recipients in general, not that they provide the best or any particular form of rental subsidy. The court also ruled that potential future tenants could not claim the protection of the subsidy discrimination statute with respect to project-based subsidy. And this was based on a technical reading of the statute, which bars discrimination against a tenant holding a subsidy, since project-based subsidy attaches to units, not tenants. Future tenants were not holders of a project-based subsidy. So the bottom line, I think important takeaway from this subsidy discrimination ruling is that the SJC has clarified that owners may choose among lawful alternative subsidies as they see fit based on the needs of their own business models. And secondly, that in doing so will not subject them to a successful claim of subsidy discrimination. This is an important development under Massachusetts law, but I think it could also be a useful analogy under any other state subsidy discrimination law if that law has terms similar to what we have here in Massachusetts. So at this point, I think I'll turn it over to Harry, who's going to talk about disparate impact and the inclusive communities decision.
Thank you very much, Janet. And again, good afternoon to everybody. The Burbank decision that Janet explained demonstrates how important these fair housing concepts are to owners and managers. And actually, the Burbank case drew a lot of attention nationwide because if the SJC had reached conclusions different than those that Janet described, it would have dramatically affected the way in which property owners and managers operate their property. And even as it is, it provides important guidance to all people who are involved in affordable properties and market rate properties around the country to get a sense of what disparate impact can mean to them and to their operations. So we're going to talk for a few minutes today about the broader context out of which the Burbank case arises, and that's the entire concept of disparate impact discrimination. Let's begin with a definition of what disparate impact is, just so everyone's clear. Disparate impact arises where a policy or practice is adopted that, although it's neutral on its face, meaning it doesn't discuss any issues that directly are prohibited by the Fair Housing Act or state or local fair housing laws. It's neutral on its face, but nevertheless has a statistically significant negative impact on one of more of those groups of persons who are protected by those statutes. The primary reason why disparate impact is favored by plaintiffs over other forms of fair housing liability, and we'll talk about that in a minute, is that it does not require a showing of intent. Rather, it concentrates on the question of the statistical or quantitative impact, if you will, on a particular class to ask whether a policy, even if it's not intentionally discriminatory, has a harsher impact on one of those protected classes. Clear and classic example of disparate impact, just so we're all on the same page here, would be a property that adopts a two-person per bedroom occupancy rule. Assuming a couple moves into a one-bedroom apartment that has a two-person per bedroom occupancy standard, that's not a problem. But if that couple has a child or adopts a child, there are now three people in that one-bedroom apartment, and that would violate the two-person per bedroom occupancy standard. At that point, the family has an opportunity to a choice, I guess, of either moving to a larger unit or moving out of the property. So applying a strict two-person per bedroom rule, although it's facially neutral, that is, it doesn't discuss the status or age of the residents, the familial status of the age of residents, nevertheless may have a disparate impact on families and could conceivably open up a fair housing violation. Disparate impact should be distinguished from the other primary theory of liability under the fair housing laws and under anti-discrimination laws generally, which is disparate treatment liability, and that is, simply speaking, intentional discrimination demonstrated against members of a protected class. The classic example would be putting up a sign that say, no blanks need apply for a unit, and you can fill in that blank with any person who is otherwise protected by the anti-discrimination laws. The problem that disparate impact imposes, and the reason why it can have an impact on how people operate their properties, is that we live in a very diverse society. It's distinguished by race, by gender, by age, familial status, disability, and so forth. So almost any policy that we draft may in fact have a disparate impact on someone. So the important thing to understand from today's discussion is how the courts are looking at those issues and how those matters are likely to be addressed in the future. Next slide, please. The most important recent decision, other than the Burbank decision, that addresses this question is the Supreme Court's decision in the Inclusive Communities case, which was released in June of 2015. Again, a little bit of background. How did this happen? How did this case arise? The plaintiff in that case was Inclusive Communities Project, which is a nonprofit based in Texas. And it claimed that the Texas Department of Housing and Community Affairs, which allocates tax credits, low-income housing tax credits in Texas, had to follow policies that had a disparate impact, disparate negative impact on minorities' housing opportunities there. Essentially, the agency involved followed IRS guidance and allocated most of its tax credits to lower-income neighborhoods that had the greatest need for affordable housing, statistically. In Texas and in many other parts of the country, that meant that it was allocating most of its affordable housing or lower-income housing tax credits to these communities that were disproportionately minority. The plaintiff's claim was that by following these policies, the agency tended to make it more difficult for minorities who wanted to obtain housing outside of these areas, and what are referred to sometimes as high opportunity areas, that is, places with higher income, better schools, better transportation opportunities, and so forth. Originally, the Texas District Court, looking at the facts, found in favor of the plaintiff and concluded that even though the agency was following the IRS rules, its policies did in fact have a disparate impact on minorities and established liability here. In doing so, the district court was following what most federal courts have done over the last several decades. Many of these courts that have looked at the matter have concluded that disparate impact liability exists under the Fair Housing Act, and the district court in Texas was in line with most of those decisions. Next slide, please. Next slide. Thank you. But nevertheless, although most of the federal courts had addressed this issue, there remained questions with respect to whether, in fact, the Fair Housing Act did allow for disparate impact. Because if you look at the language of the Fair Housing Act, it prohibits discrimination because of race, religion, and so forth, because of those protected classes. And the implication of that strict language is that discrimination had to be intentional. You had to discriminate against someone because of their race. And if you didn't have intent, the argument went, there was no violation, and therefore no disparate impact liability. But in his 5-4 majority decision, Justice Anthony Kennedy in June of 2015 concluded that, in fact, the Fair Housing Act did embrace disparate impact liability after looking at the language of the statute and the ways in which courts and Congress had treated the Fair Housing Act and these notions over the course of several decades. Although he recognized that disparate impact exists under the Fair Housing Act, much of his decision was full of caveats and cautions. He warned that disparate impact can, in fact, have an unintended and adverse consequence where it's misapplied and can actually, in some instances, frustrate legitimate decisions reached by Congress and agencies and private housing providers in the course of their day-to-day operations. Accordingly, he recommended a number of safeguards that he thought would be necessary to protect against abuse of disparate impact claims. Next slide. The first of these is the one that Janet mentioned earlier. Justice Kennedy stressed that when in making out its initial, what we call prima facie case, the burden was on the plaintiff to demonstrate a robust causality requirement. He's concluded that a mere statistical disparity was not sufficient to support disparate impact claims, and that the plaintiff had to go further and actually demonstrate that the challenged policy or practice was the cause of the injury that was complained about. He stressed, for example, that in many instances, in many cases, a policy or practice, or rather a discriminatory situation, can arise from a number of different factors or causes, and unless you can put your finger on one particular cause, it's kind of hard to say that's the cause of the policy that's being challenged, and that's pretty much what the Supreme Judicial Court found in the Burbank case. Among other things, he said that a lot of factors go into a decision whether to build or not build a particular multifamily housing property in a given place, and he questioned whether, given all the factors and all the decisions that went into locating a property at one whether any one of them would be sufficient to maintain a fair housing case. Next slide, please. The next safeguard that he mentioned is the idea that when a plaintiff does make a prima facie case, does establish this robust causality requirement, the burden should then shift to the defendant, an agency or maybe a private housing provider, to say it had a good reason for doing what he did. He said that these folks should be given a leeway to state their, quote, valid interest that was served by the policy that they adopted. Among other things, he recommended that people, make clear what the reasons are, and I think it's a very sensible thing for people who are engaging in policies with respect to admissions of tenants and so forth, to look at the potential impacts their policies might have, and if necessary, prepare a little memorandum or something that can go into the file explaining what their reasons are and why they did what they did, so that if at some point in the future that policy is questioned, you've got a contemporaneous record explaining why you did what you did. The other factor that the judge, Justice Kennedy, looked at and put a lot of weight on was his view that disparate impact should be used to root out situations where a policy or practice imposed an arbitrary, artificial, and unnecessary barrier to fair housing. The strong sense was that this is sort of a smell test, and if it seemed as though the policy that was being challenged raised artificial barriers, those are the kind of barriers that should be taken down, and not otherwise legitimate decisions by government agencies or private entities about the way in which they do their business or manage their properties. Next slide.
Harry, I guess I'll take over from you then to discuss. Did I miss a slide or?
Nope, you're up.
Okay. I think I'll now discuss the application of the inclusive communities disparate impact analysis as it was used in the Burbank decision. First of all, the SJC made some important, I call them preliminary decisions, but they were vital to the rest of the decision. First, it actually held that the state housing discrimination statutes, like Title VII, do provide for disparate impact claims. That's something that had never before been directly addressed in Massachusetts. And then, as a preliminary matter, perhaps most significantly, the SJC did decline to adopt a per se rule precluding disparate impact liability under fair housing statutes, even where a property owner has acted in accord with statute regulation and contract absent evidence of intentional discrimination. They gave several reasons for this. One was that fair housing statutes don't explicitly exempt fair housing laws, exempt from fair housing laws compliance with federal government programs, and that fair housing laws, under fair housing laws, violating statutes and regs has never been a prerequisite to disparate impact liability, and almost every action that could create such liability is, as here, voluntary. And lastly, as a result of this, the court said that really a commitment to fair housing in housing discrimination laws at least requires an analysis in each situation to determine whether owners' actions were sufficient to insulate protected classes from discriminatory negative impacts that those actions, quote, might have caused. I grant you that none of these explanations for rejecting a per se exemption for owners who follow law really give any actual guidance to owners as to what the court would be looking for to determine if actions might have caused negative impacts on protected classes. But I think we can discern some of the court's thinking when we look at how the SJC actually applied the inclusive communities disparate impact analysis, which it went on to do after making these preliminary rulings. So after reviewing the inclusive communities pleadings requirements that Harry just described, which the SJC called a heightened pleading requirement for fair housing disparate impact cases, heightened over what would normally be required in pleadings in other types of cases. After doing so, the SJC ruled that the plaintiffs had failed to meet those requirements. Because the owners complied with the law requiring the shift from project-based subsidy to enhanced vouchers, the plaintiffs could only point to speculative prospective harm to both present and potential tenants. With respect to existing tenants, the court ruled that since everybody had received an enhanced voucher, and the plaintiffs could only claim that perhaps someday in the future enhanced vouchers would not be sufficient to cover rents at Burbank, or that income rescreening, for instance, which is required every year of tenants, might result in having some tenants lose their subsidy. Since those were the only types of claims that the plaintiffs had alleged, the court said those were too speculative. With respect to prospective future tenants, the court said that the plaintiffs could only speculate that tenants on the Burbank waiting list might someday have the opportunity to move in and might be unable to meet the Burbank rent with conventional voucher subsidies. The court said all of this was way too speculative to state a present-day claim against Burbank under the Inclusive Communities case. But I think what I took as most important in this part of the decision was that the SJC found that plaintiffs did not meet the robust causality requirement of the Inclusive Communities case, because the Burbank owners had actually, through the terms of the enhanced voucher program, obtained many more enhanced vouchers that had ever before existed at Burbank. Therefore, the court actually, in essence, ruled that the plaintiffs could not allege that the owners' actions had caused a negative disparate impact on protected classes at all. Now here is where the SJC provided situations and examples where an owner might be vulnerable to disparate impact claims, even if they comply with the law of the federal programs in which they're participating. One example was if owners do something that, quote, exacerbates the differences between project-based and tenant-based subsidies. And the example they gave was, for instance, if owners, once the programs ended, raised rents so high that public housing authorities administering the enhanced voucher program would simply refuse to pay those rents as unreasonable. And as many of you I'm sure know, even though enhanced vouchers are required to pay fair market value, the housing authorities do retain discretion to make reasonability determinations. That is, that enhanced vouchers can't be used at any level of rent, no matter what. So they will make those determinations. If the owners attempted to do something like that, the SJC was saying that that might offer an opportunity to claim a disparate impact on protected classes. Another example was that if owners take actions that would directly exclude protected classes from certain neighborhoods, and some of this is what Harry talked about. The examples they gave were, for instance, demolishing subsidized developments upon the expiration of all of these programs, which actually did happen in one case, and that case was allowed to go forward on a disparate impact claim. Although I believe that ultimately the disparate impact claim did not succeed there. Another example they gave was owners refusing to take any subsidy at all, just opting completely out of the subsidy programs. And then for public entities, an example would be passing zoning ordinances that work to exclude low-income or subsidized tenants, such as family size limitations, as Harry mentioned, or blood relative renting requirements. So I think that what the SJC ultimately did here was that after rejecting compliance with the law as an exemption from discrimination claims, it actually validated compliance with the law as a sort of safe harbor, in fact, for owners. I think the bottom line is that if in the situation faced by Burbank's owners, you comply with all applicable termination requirements and comply with the Alternative Enhanced Voucher Program, claimants will in essence be unable to show that you caused a disparate negative impact on protected classes, but only so long as you otherwise don't do nothing extraordinary that would nullify the beneficial aspects of those termination requirements. One final practical note concerning whether owners must participate in some form of Section 8 subsidy program, if requested by tenants to do so, is that I would tell you that not all the courts agreed with the SJC that refusal to participate in voluntary subsidy programs might subject you to a claim of housing discrimination. Right now, 4 appellate courts, high-level appellate courts, have ruled on this issue, the Mass SJC and the federal appeals courts in the 2nd, 6th, and 7th circuits. And right now the score remains 2-2 among the higher appellate courts, with Massachusetts and the 6th Circuit ruling that refusal to accept any Section 8 subsidy at all could be grounds for a disparate impact claim, whereas the 2nd and 7th Circuits have ruled that because the program is voluntary, owners refusing to accept subsidy could not be subject to that kind of claim. And the U.S. Supreme Court has not yet resolved that issue, so stay tuned on that one. And I think this could be an issue for you whether or not you are currently, you currently have project-based subsidy at a development, because the issue could come up with respect to any kind of housing subsidy, including housing choice vouchers. Harry, do you want to take it back over to discuss some of the other implications of the decision?
Sure. Thank you very much, Janet. So far we've focused on 2 very important court decisions discussing disparate impact and other forms of housing discrimination. But the courts are not the only parties that are looking at this. Back in February of 2013, HUD adopted a regulation that formally, at least for HUD's purpose, codified what disparate impact is under the Fair Housing Act and what is required to show it. The thinking here was that HUD knew that cases like inclusive communities in Burbank were out there, and that if HUD took the lead, because it's the party identified by Congress as the chief enforcer of the Fair Housing Act, if it took the lead to confirm that, in fact, in its view, disparate impact liability did exist, and to state the ways in which a party would be required to prove or disprove the existence of disparate impact liability, that the courts would defer to HUD's judgment and follow that. To some extent, the courts are doing that already, but it's important to understand at least what HUD thinks disparate impact is and how it can be proven in order to see how it might work out in practical situations. So much like Justice Kennedy, HUD begins by saying that if a party wants to make a disparate impact claim, it has to make out what HUD refers to as the prima facie or first look case, bringing forward evidence that a policy or practice, while neutral in its face, does in fact have a disparate impact on a protected class. HUD does not stress the robust causality requirements that Justice Kennedy stressed as a safeguard in inclusive communities, but arguably it's in there and is the first step that's required to bring a disparate impact case. Assuming that the plaintiff makes out its prima facie case, then the burden shifts to the defendant to rebut that claim of discrimination by showing a legally sufficient justification for the policies or practices it was pursuing. This is a somewhat more complicated concept in the regulations than the valid interest that Justice Kennedy referred to, but conceptually it's the same thing, and basically it's a statement that don't blame me for what happened here, I had a good reason for doing what I did. If the defendant then meets that burden, the plaintiff gets the burden again, burden shifts back to the plaintiff, to demonstrate that there was a less discriminatory alternative that could have been adopted that would have been just as successful dealing with the problems that the plaintiff, or rather the defendant, identified. As I said, some of the courts that have looked at this have adopted HUD's regulations as binding and deferred to HUD. The Supreme Court mentioned them but didn't say one way or another whether it was going to defer to those regulations. But HUD has not wasted time. About 8 months after the Supreme Court's decision in inclusive communities, it issued, through its Office of General Counsel, guidance dealing with the topic of using criminal background checks to screen applicants for rental housing. Applying the disparate impact regulations that HUD had previously announced, the Office of General Counsel pointed out that, or claimed at least, that the use of criminal background checks to screen tenants could have a disparate impact on minorities. The argument that HUD made was that because minorities in this country are arrested and convicted and incarcerated in numbers disproportionate to the population as a whole, even a neutral policy that applies crime screening will tend to disproportionately disqualify minority persons. We can go into these things in a bit more detail, but the primary takeaway from HUD with respect to crime screening was that owners and managers should not use arrest records to screen tenants because arrests do not themselves indicate actual criminal conduct. If you're going to use crime screening, they should be based solely on conviction records. Owners should not adopt one-strike rules. In other words, owners should not adopt a policy that says that if a person has ever in the past had a felony conviction or any other criminal conviction, that they won't rent to them. Instead, HUD said that owners should stress the nature, severity, and recency of the criminal conduct in order to assess whether someone did pose a real threat. And then, as a final step, it stressed that the individualized assessments need to be done as a sort of less discriminatory alternative to make sure that even if somebody does have a criminal record, that record really does pose a threat to other tenants or staff at the property. Next slide, please. What we're seeing here is an attempt to sort of categorize decisions that have been coming down from the federal courts in the time since the Supreme Court rendered its decision in inclusive communities, just to see how the courts are adopting and pursuing the policies that Justice Kennedy discussed there. Perhaps the lead case that we should talk about is the inclusive communities case itself, which went back down on remand, and on remand was dismissed. The same judge, looking at the same facts, concluded that in light of the robust causality requirement that Justice Kennedy had identified, he did not feel that, in fact, the policies that were being pursued by the Texas agency were the cause of the discriminatory conditions that the plaintiff was alleging there, and as a result found that they did not satisfy those standards. Janet has discussed the Burbank case at length, and then clearly, if the Supreme Judicial Court had ruled that disparate impact required owners to renew their Section 8 contracts, that would have been very concerning. A series of other cases have come down in which banks have been sued, largely by municipalities, alleging that their conduct in making loans to minority populations prior to the Great Recession contributed to the blight and other harmful outcomes for minorities in those cities. And again, the courts, applying the concept of robust causality, concluded that the bank's lending policies and practices did not themselves have a disparate impact. Another case that's interesting is the Ellis case from Minneapolis that involved code enforcement by the city, and the court concluded that the city had good reasons for strictly enforcing building codes and anti-blight rules, even if those tended to have a harsher impact on housing, affordable housing properties in the city. Next, please. Oh, go back one slide. Thank you. If you look, however, at a number of other decisions that have come down, you see a different outcome here. In time after time where courts are looking at zoning practices that are adopted by local governments, they're finding that those zoning practices do in fact raise disparate impact concerns if the city or town is attempting to restrict the ability of affordable housing developers to develop housing in those neighborhoods. There's also a case in New York City, the Winfield case, which is challenging the city of New York's practice of requiring that 30 to 50% of all new affordable housing properties be reserved for people who live in the neighborhood where the housing is built. Although it might be helpful to combat NIMBYism and to encourage people to support local housing, it also, according to the plaintiffs in that case, has a disparate impact because it tends to make it more difficult for people in other neighborhoods to move in and thereby tends to reinforce patterns of segregation. And so if you look at the way the courts are coming out, it seems to me an argument to be made is that the courts here are applying that artificial, arbitrary, and unnecessary standard in such a way as to make a distinction between a bank's lending practice or a decision by an owner to renew or not renew a Section 8 contract, which I think the courts would conclude is not really an arbitrary barrier, versus those situations where towns and municipalities are shaping their zoning policies and practices so as to discourage development of affordable housing. That may be, in fact, according to these courts, an artificial and unnecessary barrier. Next slide, please.
So at this point, I think, in conclusion, we would circle back to our original question of who's in charge here in regard to how these programs are handled. And I think, in summary, I would say that while federal housing laws have shaped property management issues for many years, right now courts seem to be reluctant to interfere with owners' fundamental business decisions, such as how and when to terminate participation in federal housing programs and what form of alternative subsidy programs work best for them as owners or managers of a development. But at the same time, owners have to be very careful to be vigilant when taking actions that might change the availability of housing, at least for existing tenants. Harry?
Thanks, Janet. And I guess my final takeaway point here is that, like everything else, we need to keep an eye on what HUD's going to do and what the courts are going to do. In some respects, based on its HUD's disparate impact regulation and the Office of General Counsel guidance it put out, it looks like, at least at the moment, HUD has been pretty aggressive, more aggressive, in pushing these concepts of disparate impact and trying to expand the concept as fully as possible, which could lead to additional burdens on owners and managers and so forth. On the other hand, the courts seem to be a little bit more reluctant than HUD and have been somewhat skeptical about disparate impact claims, at least in those instances that don't involve matters like zoning and preferences and so forth, that don't strike the courts as being some sort of artificial or unnecessary barrier. And of course, we've got a change of administration now. The present administration has been very aggressive on fair housing and anti-discrimination measures generally, and presumably the new administration may have some different priorities and may not treat these things in the same manner, and may appoint persons to the Supreme Court who have different approaches and perhaps different points of view. Both the HUD regulation, the disparate impact regulation, and the inclusive communities case are in fact now baked into the law. It's not an easy thing to repeal or retract a regulation unless the agency has good reasons for doing so. Similarly, it took many years, decades in fact, for the Supreme Court to take the disparate impact decision up in the inclusive communities case, and it's not likely that, having visited this matter once, the court's going to be anxious to pick it up again anytime soon. But we live in interesting times, and obviously the future is for us to speculate about, but not necessarily guess too accurately about. So I do recommend that you continue to pay attention to what the agency, what HUD itself does, and what the courts do on these matters going forward.
Okay, thank you, Harry. So at this time, let's see if there are any questions. Here's one. Does this decision mean that tenants may not file discrimination claims against owners for terminating project-based Section 8 contracts if enhanced vouchers are available for tenants? Well, the answer to that is no. Anybody can file a claim. I think that Burbank and inclusive communities stand for the proposition that in order to get past the complaint stage and into full litigation mode, plaintiffs must be able to cite to facts that show something more than was shown in the cases of inclusive communities in Burbank. Otherwise, their cases will get dismissed at the earliest litigation stage. Harry?
Sure. Here's another question. Let's see. Someone asked to know more about what a legally sufficient justification is. That's the language that HUD said a defendant had to satisfy in order to be able to rebut prima facie case of disparate impact. The question is, tell me more about what a legally sufficient justification is. How do I know if I have a rationale that satisfies this rule? The specific language that HUD says, it's a kind of a complicated concept, but it says that in order to have a legally sufficient justification, an owner has to show what it refers to as a substantial, legitimate, non-discriminatory interest. In other words, you can't come up with a rationale after the fact that supports the policy that you chose. And that's why one of the things that I recommend is that people, when they're looking at these kind of inflection points, the points at which you decide I'm going to adopt a policy about who comes in or who doesn't come in, you take some time to study the matter, think about the potential discriminatory or disparate impacts, and if you feel that a policy must be adopted, put something down in writing so that you can explain to yourself later and not have to cobble together dozens of emails 10 years after the fact, why you did what you did and when you did it. The HUD's view of a legally sufficient justification also doesn't put a burden on the defendant to demonstrate that what it did was the least discriminatory thing it could do. As I indicated, according to Justice Kennedy, he thought the burden to do that was on the plaintiff, not on the defendant. So there remains some, I think, some ambiguity that the courts are going to have to look at in terms of what is, in fact, a legally sufficient justification and whether HUD's definition complies with the Fair Housing Act.
Okay. Let's see. Someone else is asking about whether these rules that we've discussed about the enhanced voucher program apply outside of the situation where mortgages are being paid and regulatory agreements canceled. How do these cases apply to our situation where we paid off the HUD-financed mortgage and previously opted to continue the project-based Section 8 contract if we now would want to terminate that contract? I think the answer to that is that the statutes mandating conversion to enhanced vouchers on termination of project-based Section 8 contracts, and that would be, for anyone who's familiar with them, one is called MARA, and then there's also the Section 8 statute, 42 U.S.C. 1437 FT. They both apply to termination of the project-based Section 8 contract in all situations, whether or not the termination is in conjunction with the payoff or prepayment of publicly financed mortgages. So if, for example, you elected to continue your project-based Section 8 contract after paying off a mortgage, you would still, I believe, be required to enter into the enhanced voucher program on termination of the project-based contract.
Janet, somebody has asked a question that I believe relates to the crime screening policies that the Office of General Counsel announced. And I think it's an interesting question with a number of different folds. So if you don't mind, I'll read that and take that one next. The questioner says, the recommended protocol is to use a screening company, but they need standards by which to uniformly screen. If we consider case by case, how is that also not a form of discrimination because it allows for subjective review? And how are any standards to be set within one strike recommendation? That question, there's a lot in that question. Try to be as straightforward and quick as possible. I think as I understand HUD's rules, and I think what HUD is saying here is that it wants in the first instance to encourage owners to move away from these one strike policies so that any past history of crime is disqualifying, and to adopt what it referred to as an analysis based on the nature, severity, and recency of a crime. That word recency, whenever I type it in my spell checker, it comes up and asks me to change to decency, but recency is apparently a new word that I haven't seen before. But I think what I was getting at is it wants owners to make a distinction between, for example, a violent felony and perhaps a misdemeanor possession of marijuana or something like that, and how long ago. So, conceivably a violation or a conviction for possession 5 years ago might not be disqualifying, but a conviction 3 years ago for violent assault might be. So what I would encourage owners and managers to do is to speak to the screening companies and have them define a series of categories of crime, violent felonies, fraud, DWI, DUI, drug possession, and so forth, distinguish those categories of crime, and then assess different look-back periods for each. And at that point, if you get a hit, so to speak, on any of those categories, that's the point at which an individualized assessment can occur. And at that stage, an owner can take perhaps a more detailed look to determine how old the applicant was when the crime occurred, or if there were other extenuating circumstances that it wants to consider. I do agree, however, that the question has put the finger on the button here, because whereas a one-strike policy may have a discriminatory impact, it is at least objective. It's irrespective of your status in the protected class. If you've got a conviction, you're not going to be qualified to rent there. If you go into a process of individualized assessment, even as a sort of a second step or a mitigating situation, unavoidably other considerations are going to start winding their way in, and there's many places where intentional or even unintentional bias can seep into this kind of system. So I don't think that individualized assessments are necessarily a solution to the problem, and they could in fact raise additional discrimination problems.
Thank you, Harry. I think we're just about out of time. This concludes our presentation. We hope you've found this information helpful. A copy of the presentation and the recording will be sent to you as soon as it's available. Again, we provided our contact information if you find you need additional legal assistance. Thank you for joining us, and have a nice rest of your day.
Thank you very much.